In the last few weeks, a flurry of Supreme Court decisions have made a lot of waves, but one decision with big implications for our clean water got largely overlooked, at least according to some viral claims on social media. So tonight, Casey Decker with our Verify team set out to find out if those claims are actually true.
For 50 years, the Clean Water Act has given the federal government the authority to protect rivers from pollution. But this viral TikTok claims the Supreme Court just struck the law down.
I'm literally losing sleep over the fact that the Supreme Court overturned our Clean Water Act. There's no one really talking about it. And they did it in a closed docket.
So let's verify. Did the Supreme Court overturn the Clean Water Act? Our sources, the Supreme Court, the Northern District Court of California, the EPA, and the Code of Federal Regulations. The Supreme Court did rule on a case involving the Clean Water Act this year. Unlike some other big rulings you've heard about recently, this one didn't come out in June, it came out in April. That's because it wasn't a full case with oral arguments. It was a case on the emergency or shadow docket. That's when the Supreme Court issues a temporary ruling on a case it believes can't wait to complete the normal appeals process. So, what was that ruling about? Well, the court weighed in on an ongoing dispute about how to enforce the Clean Water Act. There's a section of that law that says companies need to get state permission before they can build any sort of project that might affect the water supply. And for the past few years, there's been a lot of debate about how to actually interpret that law, specifically when states should be allowed to deny permits using this law. Now, some states, energy groups, and the Trump administration argued it should only be in very limited cases. Other states and environmental groups argue states should be allowed to reject permits for a wide variety of reasons. A recent district court ruling sided with the environmental groups. The energy groups appealed, and the appeals court has not yet issued a ruling. But in the meantime, the energy groups also asked the Supreme Court to weigh in on an emergency basis. SCOTUS agreed 5-4 to do that and sided with the energy groups. Now, because it was a temporary emergency order, we don't get any explanation as to why. We did get a dissent from the three liberal justices, Kagan, Breyer, and Sotomayor, joined by Chief Justice Roberts. They argued that this isn't really an emergency, and so there was no reason for SCOTUS to intervene in the normal appeals process. The Supreme Court's decision means, for now, a more lax interpretation of the Clean Water Act is in effect, making it easier for companies to get their projects approved. But what it doesn't mean is that the Clean Water Act was overturned. That was never even on the table here. All the court did was temporarily weaken one aspect of enforcement of the Clean Water Act. It can make a permanent decision after the appeals court gives its ruling, or just decide to allow whatever that ruling is to stand. Either way, we can verify no. The Supreme Court did not overturn the Clean Water Act. With your Verify, I'm Casey Decker.
And if you would like to learn more about how we verified this, just text the word verify to 509-448-2000. We'll send that link to your phone. And if you have a story that you would like us to verify, you can email those ideas to the email address right there on your screen.